Hello, everyone, and welcome to this presentation on mandatory vaccination policies and a legal update. My name is Karen Davila. I am with the Florida Healthcare Law Firm, and I appreciate you joining me. So the first update is, even if you're fully vaccinated, even if you take all the precautions, you can get very sick. I am recovering myself from COVID, so if my voice is a less than it would normally be, I appreciate your tolerance of that because I am still suffering from the persistent cough that seems to have hung on. So again, let's get started here. We're going to cover a series of things, and some of this may seem a little off topic, but I want you to understand this is kind of a build to why you would want to do a policy, how you would implement a mandatory vaccination policy. So first of all, why would you even consider mandating the vaccine? Then a bit about regulatory guidance and some litigation and enforcement trends, and then we'll talk about what do you do if you want to implement a policy, and how do you create a process for accommodations. One of the things that is often requested as an accommodation is remote work option. And of course, we'll talk about whether that is a viable option for our healthcare providers. And then lastly, we'll cover some key takeaways. So I think some of this is fairly foundational, but I lay this out again because as we go through this presentation, you'll understand that there are some things that you will need to be thinking about. And as you adopt a mandatory vaccination policy, you may want to educate your employees and others to assure they understand the basis for adopting the mandatory vaccination policy in your particular healthcare setting. So first and foremost, you're providing for the safety and health of your patients, or customers, depending on how they're referred to in your setting, and employees. In addition, though, you're mitigating the risk of liability that you could incur for failure to provide a safe workplace. And OSHA is the Occupational Safety and Health Act, an agency that is responsible for enforcing safe health environments and periodically evaluating in the event there is a complaint about an unsafe workplace. You also can mitigate the risk of inability to maintain your operations. I mean, if you have a widespread outbreak in your practice, you can imagine how that could prevent you from being able to carry on your business operations. And in some cases, we've seen widespread outbreaks can really bring to a halt a lot of things. And so it's important to mitigate the risk of widespread outbreak, and vaccines is one way to do that. Lastly, in terms of why consider mandating vaccines, and of course, there are probably other things you can think of, but clearly one of the other things you would be doing would be to mitigate the risk of being sued for failure to protect your patients and customers. And when we get to the litigation trends and enforcement, you'll see that some of that is already occurring in the context of COVID outbreaks and illness, severe illness, and in some cases death. So here we have some regulatory guidance. First, we're going to take a look at OSHA. Again, OSHA is responsible for regulating the safe workplace and providing guidance on providing a safe workplace. And so in January of 2021, OSHA issued its new guidance on mitigating and preventing the spread of COVID in the workplace. Some of the things you can find in that guidance reference that implementing a workplace COVID prevention program and other prevention controls measures is a very effective way to mitigate the spread of COVID at work. But you'll also see that OSHA has stated that the vaccine is the most effective way to protect against severe illness or death. So OSHA does strongly encourage employers to provide vaccines and to provide paid time off for workers to get those vaccines and recover from the vaccine side effects. Employers should work with local public health authorities to provide those vaccines at no cost to workers. They should also adopt policies that require workers to get vaccinated or undergo regular testing. So the OSHA has provided an option where somebody might not be vaccinated, and where they aren't vaccinated, they should undergo regular testing in the healthcare setting. And then also mandating face coverings and social distancing for anyone who is unvaccinated. Some additional guidance from OSHA came out and has been updated. This is the emergency standard that was issued, and the ETS has a statement that says OSHA has determined that the requirements of healthcare ETS released on June 20th, or excuse me, June 10th, remain necessary to address the great danger of COVID in healthcare. OSHA continues to monitor and assess the need for changes on this healthcare ETS each month. So since June, this ETS has been in place, and it provides certain requirements. It's by the way, ETS stands for Emergency Temporary Standard. Apologies if I didn't say that earlier. In any event, this particular guidance that was issued in June has periodically been revised and updated, but it continues to be relevant and in force. And when I say in force, it simply means that this is the latest guidance relative to the emergency temporary standard. It applies to settings where workers provide health care. It addresses limited requirements for situations where respirators are used. It incorporates CDC guidance regarding standards for PPE, as well as the EPA's, the Environmental Protection Agency's list of approved disinfectants. The emergency temporary standard does exempt fully vaccinated individuals from masking and social distancing in certain circumstances. But if an employer has more than 10 employees, a written COVID plan is required. So those of you who don't have a written COVID plan in your healthcare setting, if you have more than 10 employees, you may want to be thinking about that. And again, we can certainly provide assistance with developing a written COVID plan, but essentially you must have policies that address a whole host of aspects about how you will respond to exposures and such. We mentioned above providing paid time for employees to get vaccinated and recover from side effects. That's also included in this ETS. And you also have to have a COVID log if you have greater than 10 employees, and COVID log would be the list of exposures that have occurred in the workplace. So we moved from OSHA to CDC, Centers for Disease Control. And as you know, early on in the pandemic, CDC was actively involved and furiously issuing guidance. The latest guidance for fully vaccinated people came out on 9/1/2021, or was updated 9/1/2021. And in non-healthcare settings, they still recommend masks in public indoor settings where there is an area of substantial or high transmission, or if the person is at an increased risk for severe disease. And if somebody's exposed, they should get tested 3 to 5 days following exposure. In the meantime, of course, quarantining or protecting from exposing others. And they should wear a mask for 14 days after exposure until negative test result. I did say quarantine. What I meant was take extra precautions and wear a mask. Additional guidance from CDC. It was issued on 9/10 called the Interim Infection Control and Prevention Recommendations for Healthcare Personnel during COVID pandemic. Here, this is specific to healthcare settings, and it includes home health. The guidance refers to routine infection prevention control practices during the pandemic, including identifying and managing suspected cases, implementing source control measures, things like masking and social distancing, universal precautions, and a process to respond to exposures. And then wherever you are treating suspected or confirmed cases of COVID, there are recommendations for heightened infection control procedures. And I said ICP here, it should have been IPC, Infection Prevention Control. Okay, so under additional information from OSHA, we have some lessons learned, and these are taken from a series of documents and just kind of summarized here. But really, a workplace assessment would be useful to determine where you have potential for exposure, where respirators might be appropriate, and where PPE is required. Developing, implementing, updating a written respiratory protection program where appropriate with worksite specific procedures is critical. Providing the respirators and/or PPE where appropriate. Making sure that employees are trained to appropriately use the PPE, that it's the correct type and size, that they're trained to use respirators and so forth. And proper storage of respirators and PPEs is critical early on. When these weren't properly stored, there was damage to what was very, a very limited supply of PPE and so forth. And so we learned the hard way that we had to be careful with this, with PPE, so that it wouldn't get damaged or contaminated in the locations where it was being stored. There are requirements that if a fatality related to COVID occurs, it has to be reported within 30 days. And that's really the 30-day rule for a fatality related to a work-related incident applies to all fatalities in the workplace. Reporting the fatality within 8 hours of finding out about it. And then, of course, there are record-keeping requirements for injuries in the workplace. So the question you might ask is your workplace covered by the emergency temporary standard? This flow diagram was provided by OSHA to help you decide if you, as a healthcare workplace, are covered by this. And so I just provide that for your further review at some point, but it's fairly straightforward. So in terms of OSHA guidance, there is guidance around the development of a COVID mitigation plan. And OSHA issued 16 specific elements, but those include, by way of example, the need to have a workplace coordinator responsible for COVID-related issues, to conduct that hazard assessment that I mentioned earlier in one of the earlier slides, and specifically what you're looking for is exposures related to COVID. Conducting education and training on your policies and procedures so that your staff is aware of what you expect in terms of whether it's sanitizing, use of PPE, donning and doffing of PPE when going in and out of a room where a patient is that is a person of interest, person under investigation. A lot of that case on the TV going around, that's what came to me, was a person of interest. But anyway, allowing remote work when possible is one of the options that OSHA lists as an element to improve the effectiveness of the mitigation plan. We talked about enhanced cleaning and disinfecting. Also, an anonymous process for workers to voice concerns about COVID-related hazards. One of the things you'll hear momentarily when we talk about litigation and enforcement is that workers have been very vocal about being in an unsafe work environment and have filed numerous complaints about that, have brought lawsuits about that related to being exposed to COVID in the workplace and not being adequately protected. And then providing the vaccines at no cost and educating on vaccines, and then incorporating methods to ensure compliance. Some additional thoughts around an effective COVID mitigation plan. OSHA does recommend that employers provide all workers with face coverings at no cost unless their task requires a respirator. OSHA also recommends that employers require any other individuals at the workplace to wear a face covering with certain exceptions. So in light of COVID, what you have is recommendations from OSHA in a healthcare setting that indicate that when you have visitors and non-employees in your workplace, you should require them to wear face coverings with some limited exceptions. And the OSHA new guidance touches on COVID vaccinations by recommending that employers make the vaccines available. It does not recommend mandating the vaccines, but it does recommend that employers make them available and encourages vaccines. So when you think about what we've been through in the last year and a half, it should be no surprise that litigation has come out of a lot of the conditions that arose because of COVID in the workplace. Some of the things that occurred included employees objecting to the unsafe work conditions and objecting to the fact that they were being exposed to individuals with COVID symptoms. And typically where that occurred, it was followed by, where they objected or complained, it would be followed by a discharge. They'd be terminated because they refused to work in the unsafe conditions or whatever. And that would trigger a whistleblower case or retaliation case or claim. And so there are a fair number of those. And the issue is always going to be whenever somebody has brought to an employer's attention the fact that there exists an unsafe work condition, and then that employee is terminated in fairly close proximity to that complaint, there is the possibility that it will be viewed as a whistleblower retaliation wrongful discharge claim. So you have to be thinking about that. And it's often the people who are who might complain may also be doing so to avoid being terminated because they are failing in performance. And so you have this catch-22 that you have to pay close attention to. Other litigation and enforcement trends we see is that there are complaints based on unsafe work conditions that have caused sickness or death, that employers have failed to protect employees, have failed to adequately clean and sanitize workplaces. So when you're thinking about this, if you have a COVID positive patient in your facility and they are in a particular exam room or whatever, that exam room, there should be heightened infection prevention and control measures taken when that patient leaves that room. In addition, failing to provide PPE or adequate hand washing stations, and enforcing some of the protocols like social distancing or requiring individuals to wear masks. Another area that we've seen litigation is in the area of disability discrimination, where we have required individuals to either, in the case of mandatory vaccines, we have failed to accommodate their inability to get a vaccine because of a disability, where they have claimed a disability that prevents them from being able to wear a mask or face covering. Again, that can be a claim of disability discrimination if we're not able to accommodate them in some other way. And then, of course, there are, as you have been hearing in the media, numerous lawsuits floating through the courts in various places throughout the U.S. regarding the legality of mandatory vaccine policies. And then lastly, I'm going to dovetail into the OSHA enforcement in the workplace regarding unsafe workplace. So a couple of the next slides relate to the statistics on this, and I think it's important to recognize that 45% of the total complaints arise in the context of healthcare. These are the complaints that are filed with OSHA concerning unsafe workplace. 20% of all OSHA inspections with COVID-related, 348 inspections with COVID-related violations have occurred since the beginning of 2021 and have resulted in penalties in excess of $4 million. So these are not insubstantial penalties, and it's important for employers to pay close attention to what the OSHA requirements are for providing a safe workplace. 20% of all complaints are in OSHA Region 4. OSHA Region 4 includes Florida, and because there are 10 regions, it should be fairly obvious that that is a higher percent in one region than you might expect to see in some of the other regions. So the cited violations we talked about in, personal protective equipment here, it's either inadequate or none at all. It is not effective. I have seen cases where employees have been told to have not been instructed to remove soiled PPE or contaminated PPE, or they've been led to believe they have to reuse it. Those can all cause citations. Respiratory protection is another one where there are lots of citations. Blood exposure to bloodborne pathogens, and then of course record-keeping violations. The record-keeping violations also often arise because employers are not familiar with what OSHA requires them to maintain records on. And so if you need some help with OSHA record-keeping requirements, there are lots of good folks who can help you with that. And feel free to call me and we can discuss that. Lastly, there is something in the OSHA, the Occupational Safety and Health Act, called the General Duty Clause, which requires employers to provide a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm. And that has become a fairly common citation when there's an investigation or an inspection and or a complaint. And I've included the link at the bottom for the data and statistics for OSHA. So it's important also to understand that if OSHA comes, why they might come for an inspection and how that relates to COVID. What we've learned is that if an inspector receives a tip of imminent danger, they could actually come on site and do an inspection, and it's important to recognize that because they don't need to have a formal complaint. Also, if you have an outbreak in your workplace with severe injuries or illness, you are likely to get a visit from OSHA or another agency that has authority to investigate that. And then, of course, employee complaints can trigger an OSHA inspection. And an inspection or either a visit on site or formal written correspondence on the complaint, which you would then have to respond to. Referrals can also be generated from unwanted media attention. So again, an outbreak in a local healthcare setting might trigger media interest. If media becomes involved, then either OSHA or one of the other agencies could get involved to see if there is a unsafe workplace or a threat to the health and safety of individuals. And then, of course, targeted inspections are fairly routine, but relate to a kind of a national or regional program. Okay, so why did I talk about OSHA enforcement? Why did I talk about the CDC and OSHA guidance? Well, I did that in part because I want you to understand that things related to COVID-19 continue to evolve. And what we now know is that, first of all, the EEOC has said that an employer can mandate vaccines. We also know that President Biden is in the process of adopting a law or trying to get a law passed that will mandate the COVID vaccine. So there is a lot of support for saying yes to mandatory COVID vaccines. So the question then is, should an employer mandate COVID vaccines? Again, CDC and OSHA both recommend COVID vaccines. So a couple of points I want you to be aware of. Let's just talk. I mean, some people have thought for a while that federal law prevented mandatory COVID vaccines, particularly as the vaccines are in an emergency use authorization status, there was some belief that you couldn't mandate. That was untrue, and EEOC, as early as the fall of 2020, said that you could mandate vaccines. Other vaccines, as we know, have been long required in healthcare settings. Flu vaccines are mandated. TB and various other testing is mandated. And so if it is a written policy and it is enforced uniformly across your employee base, you can and maybe should mandate vaccines. There is a growing trend, of course, now to require COVID vaccines, so you won't be the leader in that. You won't be on the front line of that, because there are others who have already taken the heat. And the bottom line is, it does provide protection for patients and other employees. So in a healthcare setting, mandating the COVID vaccine is probably an important decision to make, and where possible should be adopted. There are some challenges, and you can't just adopt a mandatory COVID vaccine policy without some thought and effort. So some of the issues with mandating the COVID vaccine include employee hesitancy. And one of the best ways to respond to that, of course, is significant amounts of education, constant education on the importance of the vaccine. You also have the challenge, if you mandate the vaccine, that there may not be sufficient workforce to fulfill your jobs. We continue to listen to the jobs reports. We continue to listen to the fact that workers are leaving the workforce, refusing to return. There are a whole host of reasons, but the bottom line is, with a workforce shortage, you have to really know that you really have to set your policy and feel strongly about it to mandate vaccines, because you will experience the inability, you may experience loss of current employees and the inability to recruit new ones. The other challenge, and this is probably the most difficult challenge, other than all of the employee hesitancy, is the accommodations process that you must have. So if you're going to have a mandatory policy of vaccines, and this is true for flu vaccines, so if you mandate flu vaccines currently, you already have a process that can be used for purposes of managing accommodations requests for COVID vaccine refusals. So you need to be thinking about that, and you need to potentially work on that. And then you have to ask yourself, are there any state law prohibitions? So in Florida, there is a law that prohibits businesses from requiring customers to provide, like, their vaccine passport, evidence of vaccine or evidence that they've recovered from the infection. But that law specifically exempts healthcare providers. There is no Florida prohibition on an employer mandating vaccines for employees. And so there is no state law that interferes with your decision as a business, as a healthcare business, to adopt a mandatory vaccine policy. A vaccine mandate or testing protocols is what is being proposed by President Biden. It may be implemented at the federal level for employers with greater than 100 employees. So for those of you on the call, if you are very small practices, it still won't apply to you, but it will apply to a large number of employers in the United States. And although there is significant opposition to it, including Florida's governor and other state governors, it is moving forward with some haste, and so we eagerly await confirmation of that. In adopting a mandatory vaccine policy, you really are balancing the risk of liability for failing to mitigate the risk of COVID exposure against the challenges of managing the mandatory vaccine policy and the corresponding accommodations process and employee hesitancy. So if you're going to develop a mandatory vaccine policy, COVID vaccine policy, I recommend you have a written policy, including the rationale. And when you adopt that written policy, you should take time to communicate with your employees. In the last year and a half, having worked for a national senior living chain, I know that we spent a great deal of time and effort educating on the rationale of various things we did. We had not yet adopted the mandatory vaccine policy early on, but have since done so. But again, it can be an uphill battle. But if you put a lot of effort into your rationale and explaining that to employees, you tend to reduce the opposition. Now, I require, or pardon me, although that's a written policy is recommended, it is not required. But what is required is a process for managing exemptions and accommodations. So the two types of accommodations you have to be able to evaluate and work and develop a process to manage are an accommodation for disability and an accommodation for religious objections. So why would somebody object on a religious basis to vaccines? Well, we've heard any number of things, but some of them relate to the fact that there's a belief that stem cells were used in the development of one or more of the formulated vaccines. And so where people have a religious objection, employers must reasonably accommodate that where possible, unless doing so would cause more than, and this is the standard, a minimal burden on the operation of the business. So it's a much higher standard for an employee to demonstrate that any accommodation for religious purposes is not more than a minimal burden. For an ADA accommodation, the burden or the employer has to adopt, has to find an accommodation in more cases because the burden is much lower. So I threw this in here because it's interesting. I have dealt with this also in the context of several of the employers I've advised over the course of the last couple of years, whether it was on flu vaccines or more recently the COVID vaccines. And employers were looking at ways to improve vaccination rates among employees without mandating. Now, this is an interesting approach because in some cases, employees are very motivated by money, by financial incentives. And so in some cases, it would include things like some extra hours off, paid time off from work. It might include a gift card, might include something else. They were successful early on for early adopters of the vaccines and trying to get the vaccines accepted by employees. But you have to exercise caution. In one case, an employer wanted to do a drawing, and drawings for chance are governed by raffle and other laws. And so you have to be very careful because every state has its own law regarding raffles. So you really need to be careful with incentives. If you're doing a voluntary vaccination program and using incentives to motivate your employees, you should make sure those incentives are reviewed by legal or tax advisors. And you need to be careful that they're not so large as to be considered coercive and trigger some type of claim or lawsuit. Making vaccines voluntary also reduces the risk of ADA and Title VII claims, but there is really no assurance that you'll achieve 100% vaccination rate. And that's pretty important to realize, because if your objective is to achieve 100% vaccination rates, voluntary vaccinations may not be the way to do that. So how do you create an accommodations process? The accommodations process really is several steps, and you really need to put some thought into it. And again, I would recommend you develop a written process to do this. You have to first determine why the employee is requesting exception or exemption from the vaccine and whether they have talked to a healthcare provider regarding their request or plan to do so. If it is because of a medical or disability, they will have to have some statement from their physician, typically. Ask the employee to identify what job functions they believe they can perform or not perform, and what they would need, what type of accommodation they would need to accomplish that. Consider and really think carefully about what accommodations may be available. One of the things that employers often do is they get a request for an accommodation and the employees are already suggesting the accommodation they want. You don't need to shut that down immediately or default to the accommodation the employee suggests. But if the employee rejects any accommodation you propose, you should certainly ask them to explain their concerns, and you work together through what is called an interactive process, including the employee in the discussions, to achieve the analysis of what accommodation will work to allow the individual to perform the essential functions of their job. You have to also, and this was even more important at the beginning of COVID, because people were requesting leaves and accommodations for a whole host of things early on. And so you have to identify the applicable laws and policies. Family Medical Leave Act is most often available if somebody is either has their own medical issue or is caring for somebody else in their household. You also have the Americans with Disabilities Act that applies, Families First Coronavirus Response Act. If an employee is pregnant and there's some concern about exposure to COVID in the workplace or whatever, or refusal of a vaccine because of pregnancy, you have the risk of violating that, and so on. You can see these various laws, but you also then, if you have your own policies, you have to follow those policies as well, provided they comply with the federal and state laws. And so if you have a policy on leave of absence, make sure you're following that, like duty or transitional duty policies and EEO accommodation policies. You need to make sure you're following all of those. Okay, so once you've determined what laws apply, once you've determined the basis for the employee's request, you have to decide if they're entitled to leave of absence. There's no need to really go further to evaluate workplace accommodations if they're not willing to receive those. You have to move forward with the leave process. So if they are entitled to a reasonable accommodation, then you're looking at situations where it relates to a disability. Of course, they're entitled to a reasonable accommodation, and again, you have to determine what that is. But if it's based solely on the age of the individual, they're not entitled to an accommodation, but they must be treated the same as similarly situated younger employees. And again, this came up early on when the advice was that people over the age of 65 or 60 were at high risk and should avoid areas with COVID and COVID positive individuals. If the employee is pregnant, and again, with respect to vaccine, where you get into issues is if an employee is pregnant and her medical provider has advised that she should not get a vaccine, she may be entitled to an accommodation. Continuing discussion on the legal obligations, if an employee has a health condition that makes them vulnerable to increased risk related to COVID, they may be entitled to an accommodation, provided there is an underlying medical condition that would qualify as a disability. But if they're caring for a family member with a high-risk medical condition, they're not entitled to an accommodation, but they may be entitled to leave, as mentioned above. And then we had early on in the pandemic, people nervous about risks to themselves being exposed in the workplace, and they're not entitled to any accommodation. And of course, we've heard the stories about people wanting to collect unemployment. If you don't have a legal obligation to provide an accommodation, you then follow your policies. So exploring reasonable accommodations, there is an accommodation priority checklist that the EOC issues, and the accommodation should be considered in this order. So the first is to make an accommodation within the employee's current job. The second would be if there are other available open positions that the employee is qualified to perform, and if not, whether a leave of absence should be granted. A couple of things to keep in mind. No accommodation is permanent, and no employer is required to remove essential job functions. In fact, they're called essential job functions because the job cannot be done unless all those functions can be performed. So you can remove essential job functions, but if you do so, it sets a precedence later, and so we do not encourage you change the essential job functions. But when you're establishing what those essential job functions are, you should be cautious to make sure that those essential functions are really essential. Accommodations, and the standard for accommodation really is only if it's reasonably designed to allow the employee to work and perform those essential functions, which is why I said be careful when you're identifying essential functions and roles. It was interesting because I accepted a job as general counsel at a hospital, and the job description said I had to be able to lift X amount of pounds and perform certain physical activities as part of the essential job functions. And when I challenged that, only because, of course, I'm a lawyer and I was concerned that they had these essential job functions that may not actually be essential, we went to work on reevaluating all the essential job functions for all of the job descriptions or job description classes. So when you see that, sometimes you might need to kind of raise a hand and say, these don't seem like essential job functions. Again, I mentioned the interactive process should include the employee, and it shouldn't, be just a one-way street. And then, of course, it's important to document that process and any decisions. And the accommodation you grant is temporary and based on current patient and business needs. You don't have to grant a permanent accommodation, but in many instances, if the accommodation continues to be required because an individual can't get a vaccine or some other thing, then you have to make sure that it's an accommodation you can live with as the employer. So one of the things that has come up early on in the pandemic was many people fled the workplace to remote work options. And remote work actually is a potential accommodation for some individuals. So, what are the challenges that healthcare employers face in this context? Well, right off the bat, because healthcare is primarily face-to-face with patients and treating patients, remote work is not going to work for everybody. But you probably have individuals who are in your workplace who are not interacting directly with patients or who could do so by telephone. Examples include your schedulers or your billing and coding folks. And so if there is an opportunity to allow people to work remotely, you need to be thinking about that. There are some challenges with remote work, and we'll just, we'll talk a bit about that. But you have to really be very clear about your expectations, outline any eligibility requirements, and then uniformly apply those. And you probably want to build an approval process to allow people to request that as an accommodation. But you have to think about, a whole host of things, including the ADA implications. And lastly, I think employers struggled with maintaining and managing employee engagement throughout the early phases of the pandemic. So that was pretty critical. So a little bit more about remote work as an accommodation. You have to be thinking about wage and hour issues. Employees have to capture all their time. They can't work off the clock. You also have to be thinking about privacy and security issues. Specifically, you've got issues related to computer usage policies, but so many of us have our computers at home anyway now with remote access, and so you simply need to have good policies regarding computer usage. You have to have an appropriate mechanism for data encryption. And home Wi-Fi's can be insecure, so if you're using VPN, that adds a level of security. One of the big things that we have done across all the larger clients that I've advised recently is you want to issue devices that prevent attaching an external device, whether it's a thumb drive or downloading or uploading, because that can corrupt not just the laptop or whatever, but it can corrupt it and cause problems. And then, of course, you do want to monitor employee usage and but being sensitive to an employee's right to privacy. So we're about in the wrap up here. This is my last substantive slide. Some of the things I looked at as I went through this presentation and prepared for it was the recognition that there is now significant support for mandatory vaccines in the healthcare setting. Although there is a fair amount of private litigation that challenges the right to mandate vaccines, it is not expected to be successful. The legal basis for that litigation seems weak. And absent a mandatory vaccine policy, employers do face an increased risk of litigation and enforcement because they have difficulty protecting their employees and their patients from COVID-related exposure. So although COVID vaccines can be mandated, you need to develop those accommodation processes that I mentioned, and the two types of accommodations that we discussed were an accommodation for disability and an accommodation for sincerely held religious beliefs. That accommodation process is a two-way street, interactive, and the employee can't dictate what accommodation they want. And that is important to remember. And then lastly, if you are going to use a remote work option for an accommodation, you need to formalize that and train your employees as to your expectations and any limitations or controls on that. And again, remote work is just like any other accommodation, is a temporary accommodation, so you should reserve the right to terminate the remote work option based upon certain criteria. So with that, certainly I welcome questions. Since this is not a two-way audio, I would invite you to send your questions to my email address, which is on this last slide here, or give me a phone call at the office. I'm glad to help any of you who have questions, and I am, again, delighted that I had the opportunity to present this information to you. Again, thank you very much for joining the session this evening or today, and have a great day. I'm going to end the presentation now. Thanks.